Let's proceed.
Good morning, Mr. Chief Justice, and may it please the Court. Let me begin by introducing trial counsel who are here with me today, Mr. Elliot Weinstein and Ms. Stephanie Page. I'd like to begin by addressing something that was in the Commonwealth's brief, and it involves the emergency aid doctrine. The Commonwealth argues that a reasonably objective police officer could have thought before the second search that the Entwistle family was still in the house. There is no factual basis for that in the record, and it's unfounded.
Does it matter? Does it matter?
Does it matter? Not under these circumstances.
Does it matter that there might have been evidence in the house that would have given a clue to where they might be? They were missing persons, after all.
Right. But we have the Fourth Amendment in Article 14 requires probable cause, or at least under the emergency aid doctrine, which means an emergency and a belief that someone is in the house in imminent need of assistance.
People are missing.
Right.
People are missing.
Right.
A baby is missing.
Right.
What's not emergency about that?
After the second search, it was no longer an emergency.
They're now missing longer. Now there's true additional added concern about their well-being. They need to be found. There may be evidence in the house as to where they might be. Why is not that an emergency?
If that is true, then the police should have obtained a search warrant, which they could have tried. Maybe they would have gotten it. I don't know. But we have the fourth.
We're not talking about a crime here. We're talking about missing people.
Well, there's no distinction under the Fourth Amendment between investigating crime and other functions of the police. And there's a Supreme Court case.
There isn't a distinction at all?
Not from a constitutional standpoint.
But there certainly are circumstances under which a warrant is not required, and emergency assistance is one of those.
Right. But
as long as the police act reasonably.
The touchstone is reasonableness, but we're dealing with a house.
Can you tell me how much time passed between the first search and the second search?
Yes. The record is a little bit unclear, but I can get it relatively close. The first search, the phone call to the police came in, I believe, at around, I want to say 5:30, 6:30. So I would, based on my reading of the record, the first search, let's say, occurred around 7 o'clock on Saturday night. The second search, the Matarazzo family showed up at the Hopkinton Police Department at around 5 o'clock, and the detective was out at the house probably shortly. Well, he was already on. Well, he went out there. He came on duty at 4 o'clock. So I would assume that search occurred probably sometime between 6 and 7 o'clock in that time frame. It was almost a full day. It wasn't 10 minutes or 15 minutes later.
Now let me ask you about your original proposition. Let us assume here that the police chief at 6 p.m. on Sunday, more than a day has passed, no cell phone contact, no indication, no word, concern is greater, brings in the officers who conducted the protective search on the 21st and went over with the officers what they actually did. Mm-hmm. And learned that they had actually not gone into any closets. They had not done a comprehensive search of the bedrooms, and said, you know, I'm not confident that you did a good enough job to be examining the possibility of finding somebody. I think you better go back and do a better job of doing that because there are places you did not look. Would that not be reasonable?
I don't believe it would be reasonable because that goes beyond the purposes of an emergency aid search. An emergency aid search, this wasn't a protective sweep like in the...
well, in terms of its scope.
Right, in terms of scope. It was, they walked into each room, looked around, didn't see anybody. This was not supposed to be an emergency aid search. Is not, let's look in every closet, let's look under the bed, let's see if there's marijuana on the bed. As in the most
well, they're not looking
case.
for marijuana. They're looking
right.
for
That's
people.
Right.
And
That's
there
right.
were places where people could have been, and obviously there were places where people
That's right.
could have been, but even without needing to rely upon hindsight, if the officer had described the nature of the search, would it not be reasonable for the police chief to say, you know, that really is not as comprehensive as needs to be done given the nature of the concerns that we now have and which are now greater than they were 24 hours ago?
Well, my response to that, I believe the appropriate response for the chief of police in Hopkinton would have been said, let's go in front of an independent magistrate and present it to him or her. And if him or her says, here's a warrant, so be it. But the emergency aid
A
doctrine is
warrant
very,
based on what, though? A warrant, not probable cause to believe a crime was committed. Judge Kottmeyer found there was none.
Right, she did find that. It would be something along the lines of that a search is reasonable under the Fourth Amendment. And by the way, there is a statute in Massachusetts that talks about what constitutes a search. The law is unclear whether you can do searches for non-criminal activity. But the law is unclear, and it could go either way. But my response to you, Justice Gantz, is that we have the Fourth Amendment, we have the 14th Amendment. The search must be reasonable. The emergency aid doctrine is limited to two situations where you have an emergency and a person in imminent need of assistance in the house. It had been 24 hours. If they were looking for bodies, okay, it's probably not even an emergency anymore, and they certainly, unfortunately, probably not in need of immediate aid.
But you used the word probably. And
Probably,
that
sure.
means there was a possibility that they would still be alive, albeit severely injured. So isn't that possibility, given the gravity of the situation, enough?
Again, unless we're going to have a missing persons exception to Article 14 or the Fourth Amendment, the searches were not reasonable under the Supreme Court's two cases involving the emergency aid doctrine. I'm not sure if I can answer it any better than that.
Counsel, there are so many cases where the fact patterns involve something terrible happening to a parent, and then a child is found still alive 2-3 more days later. Couldn't that have been reasonably in an officer's mind, looking back? Time is ticking. There is a child.
Well,
They could be alive. Lots of things could have happened.
sure.
Some of them did.
But at least under the facts that are in the record in this case, you have officers who said on the record, I did the search, it was complete. I didn't think
We look
anybody
at
was
it
in the
now-
house.
We look at it now through a different filter, right? The reasonable.
Well, after the fact, sure. But again, this court has to think long and hard about whether they want to make an exception to the emergency aid doctrine or some lower standard of proof or some lower standard of probable cause that there's someone in the house for missing persons. And I'm not aware of any
They couldn't have gone
court that's
in,
done
so
that.
do we just wait at that point? There's no probable cause at that point, so we just wait.
I would say that the emergency's over. Officers had gone in the house and look elsewhere. And they did try looking elsewhere. I mean,
Just not go in the house?
I don't think you can go into the house. I
Until-
don't think the Fourth Amendment allows officers to go in the house to go search for paperwork
Can you
where
just
people
tell
are
me what the
located.
next step would have been after, in your scenario? I'm just trying to follow through. Let's say we go in your directions. Okay, you try to get a warrant. Looks like you're not going to get one. No probable cause, no crime. And then the next step?
Well,
in
maybe
this
it's not just
investi-
limited to probable cause that there's a crime. Maybe the independent magistrate would have to say, this is still, and this is, I mean, the technical requirements of the Supreme Court's cases on the emergency aid doctrine are not met, but I've listened to this. I'm the independent magistrate reviewing the case, and I will issue a search warrant. That didn't happen in that case. It could have happened, but it didn't happen in this case. And I think to give the police carte blanche, literally blockbuster carte blanche, to go in and break into a house under these circumstances, especially after the police had been in the house the day before.
At the urging, of course, of the victim's mother.
True.
So just they didn't break into a random house. The
True.
family was extremely concerned. They had
True.
every reason to be concerned that something was very wrong, and that their daughter and granddaughter were missing.
All true.
Grandchild.
All true. But again, we're talking about a constitutional boundary.
And we're
Possibly
talking about
the most sacrosanct constitutional boundary. And this court has to very carefully consider whether they want to lower the standards of crossing that boundary under circumstances like this.
The judge also found, of course, following this sequence, you would have them not going into the house. We don't have probable cause to believe a crime has been committed, therefore we can't get a warrant, maybe. But the judge also found that that wouldn't have lasted very long because the family was going to get into that house. They'd already gained access. They had the code to the garage. They'd already been in the house to get the dog out. They were sitting in the driveway all night. They would have gone into that house.
Right.
And those
Those are,
mother and child would have
that,
been discovered.
that brings us to the second issue, the inevitable discovery doctrine.
Right.
And this court has a long line of cases going back to at least 1981 saying that the inevitable discovery doctrine does not apply where the police should have obtained a search warrant.
Well, but this has nothing to do with the police. This has nothing to do with the police getting a warrant. This has got to do with citizens, family members going into a house, inevitably going into a house. What's that got to do with getting a search warrant?
The family members might have gone, the landlord would have gone into that. Eventually, the landlord would have gone. Of course, that's
And the judge
true.
found they would have.
Probably true. But still, does that mean that this evidence, primary evidence, assuming that this court finds that the search was unlawful, does that mean that this evidence should come in under the inevitable discovery doctrine?
Why not? This is not, it would not be police action. It's not like the police went into the house and said, well, we could have gotten a warrant anyway, so therefore this is inevitable discovery. This is not that.
Maybe I misunderstood what you're saying. Are you saying that if the family members found the two bodies?
Right. I'm saying if the police had not gone into the house on Sunday, as you suggest they shouldn't have.
That's right.
The judge found that the family would have. In fact, they had already gone into the house to get the dog out of there. They were overnight in the driveway. They would have gone into the house and discovered the bodies.
Right, but that doesn't purge the taint from the evidence that was, assuming you believe that the evidence was improperly, unlawfully seized. That doesn't, after the fact, purge the taint of that evidence. And that's the issue that historically that's been the issue on the inevitable discovery doctrine.
Purge the taint of the evidence.
Right. Assuming you believe the second search was unlawful, that was tainted evidence.
And what I'm saying is it would have been independently discovered based on nothing the police had done.
But it was not independently discovered in this case.
But it would have, inevitably.
If it, under the independent, well, the independent source doctrine, which is a separate analytically distinct doctrine, exception to the exclusionary rule, requires actual proof that the challenged evidence was constitutionally procured. That didn't happen in this case. This case is not about the independent source doctrine. It's about the inevitable discovery doctrine, which is different and which has different tests. Now, the other point related to that, there's only one U.S. Supreme Court case involving the inevitable discovery doctrine. And in that particular case, and what's funny is the Massachusetts case, which was decided before Nix versus Williams back in 1981, involved a guy who had a similar Messiah violation, and they seized a suitcase. And the court ruled that the police should have obtained a search warrant. Therefore, the inevitable discovery doctrine does not apply. So all I'm saying is that we're dealing with two different doctrines, and the inevitable discovery doctrine should not apply to this case. Number one, based on established Massachusetts law, and number two, because this is primary evidence, not secondary. It wasn't derived. It's primary evidence. Primary evidence that was the direct product of this unlawful search, assuming you find it's an unlawful search.
But let's play this out. Let's imagine that the police had done what you think they should have done, which is nothing. Time would have passed. How long do you think it would have been before their bodies would have been discovered? Do you have any doubt that their bodies would have been discovered?
I personally, no, I'm sure the bodies would have been eventually discovered.
So what evidence was there from the entry above and beyond the bodies themselves?
What evidence did the police find?
Right.
They found all sorts of things in the house, and plus the condition of the body, plus the DNA they took off the body.
Well, of course, but that DNA was going to be there later.
But that was critical to the Commonwealth's case.
I'm sorry,
that was critical to the Commonwealth's case.
What was critical?
The DNA that was recovered, the body itself, the laptop. I believe the laptop was in the basement. Other things.
Okay, but my point is, I think you agree that inevitably those bodies would have been discovered.
I think that it's certainly fair to speculate that, if not. I personally believe it, but again.
Okay, but I mean, I think would be somewhat remarkable to imagine that they would not be.
Right, I think that's fair.
And so what, if they inevitably would have been discovered,
Right.
then why should we suppress it even if there was error in the earlier discovery?
Because the inevitable discovery doctrine should apply only to derived secondary evidence and not the primary evidence, because if you permit, okay, the primary evidence, the tainted evidence, the evidence that was unlawfully seized to be admissible, then you are essentially watering down, diluting, nullifying the exclusionary rule. And the best articulation I've seen of this, is by the New York Court of Appeals in the Stith case, which is in my brief. The Commonwealth, for example, also pointed out that the majority of the courts of appeals have applied the inevitable discovery doctrine to primary evidence. If you go take a look at those cases, you will find that the amount of legal analysis on this issue in those cases is little to none. Okay, again, the New York Court of Appeals, and the relevant portions quoted in my brief, has a very detailed analysis of the impact on the exclusionary rule. And again, I would point out that there is analytically there is a difference between the independent source doctrine and the inevitable discovery doctrine. And this court should maintain it should not call into question, should not abrogate, should not essentially overrule a line of cases going back to 1981 on the inevitable discovery doctrine. In my remaining few moments, I'd like to briefly address the jury selection issue. I think it's fair to say that the amount of publicity in this case, pretrial publicity in this case, was unprecedented. Rose to extraordinary levels in Massachusetts legal history. And the defendant was entitled, because of that pretrial publicity, to a presumption of prejudice. And in terms of basically what the Supreme Court cases have dealt with are that the trial judge, in terms of the jury selection process, is not entitled to take at face value jurors' claims that they can be fair and impartial. It has to be a much more discerning evaluation of whether they do stand indifferent in the case, and whether the pretrial publicity potentially might affect their fairness in the case. In this particular case, there were at least, I use the word at least because it's hard to read some of the individual voir dires. There were at least 13 times when Attorney Weinstein asked Judge Kottmeyer to ask, based on what the potential juror has heard, do you believe he's guilty? And on each of those occasions, Judge Kottmeyer either refused to do it or ignored the request. And at least 3 of those jurors got on the jury. And given the Supreme Court cases on this, Irwin v. Dowd in particular, and more recently the Skillings case, which is cited in this court's case in Tulin, the defendant was entitled to a much more discerning. The defendant was entitled to know the answer to those questions. I don't think there's any doubt that if a juror was asked that question. By the way, at least one of the jurors was asked that question. If a juror had responded to that question, "Oh, I think he's guilty," there's no doubt that person would have been removed as a potential juror, and that didn't happen. That didn't happen in this case.
But I assume. I've not looked back at the transcript, but I know the quality of the judge as well as the quality of the defense attorneys here. I assume there was questions that Judge Kottmeyer asked that went to the fairness and the ability of that person to be fair and to not come with a preconception.
There was an individual voir dire in this case. Most of the questions, the majority of the questions were leading questions. Can you be fair and impartial? Which are typical when you were a trial judge, you would probably ask those same types of questions. But in a case like this, where you have overwhelming pretrial publicity, you've got in the line getting into the courthouse lines like fry them and send them away. In a situation like this, the judge sort of bent over backwards, particularly on questions from being requested by defense counsel, and asked the questions. Again, if it wasn't, from the defendant's point of view, if the jury selection wasn't outright unconstitutional under those Supreme Court cases, then from purpose of 33E analysis, it was unfair. And I say my time is out, and unless the court has any questions, I'll rest on my brief.
Thank you.
May it please the Court, my name is Casey Sylvia, and I'm an Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. And with me is Assistant District Attorney Michael Fabry, who is the lead trial prosecutor in this case. Your Honors, the motion judge in this case properly denied the motion to suppress because when the police entered the Entwistle home on January 21st of 2006, and again on January 22nd of 2006, they were acting well within their role as community caretakers.
Well, on January 22nd, I mean, you argue in your briefs that they had reason to believe that there might still be people in there. Is that really credible? I mean, the judge didn't find that by any means.
Your Honor, I think that is credible. I think when the standard that we apply is an objectively reasonable standard, what the judge found in her decision on the motion to suppress is that the officers had the subjective belief that there wasn't anybody in the house at that point and that they intended to go back in for the purpose of finding information as to that missing family's whereabouts. Having said that, I don't think it's surprising that the officers that did the search the day before probably thought that they did a good enough job when it came to the search. However, an objectively reasonable person might feel differently. An objectively reasonable person, as Justice Gantz pointed out before, perhaps another police officer in the same department, perhaps the police chief, could objectively look at that and say, guys, you didn't go into the master bedroom bathroom, you didn't step more than 1 foot into any room, and you didn't go into the closets. And so I think it's objectively reasonable to believe that there could still be persons inside that home that were either dead or dying, that were in need of assistance. And in fact, although I know that we don't look in hindsight, that would have been quite correct. There were people that were dead in that home. And especially when you're talking about a 9-month-old child who can't speak, who's missing. I think that it's particularly fair and particularly reasonable to believe that that 9-month-old baby could be severely injured and in need of assistance, and that individual's presence wouldn't be as readily apparent as an adult.
Well, does your argument depend on us concluding that there was such a basis?
No, Your Honor, I don't think it does. I did want to advance that argument for obvious reasons. I do think it's objectively reasonable. Having said that, I also think it was reasonable. The officer's stated intent in going in to look for information to try to discover that family's whereabouts and to render the assistance that they believed they needed was more than reasonable. And I think it meets it certainly meets the standard set forth in all of the emergency aid cases, which is there were reasonable grounds to believe that an emergency existed, a missing family of 3, including a 9-month-old in the middle of the winter, and the police actions were entirely reasonable in the circumstances. They were calculated towards finding and assisting the Entwistle family at all times.
But I gather there are federal circuits which say that that doctrine does not include the home. It includes a car, but not the home.
There may be federal circuits that have found that. That is not the case in this court. There are any number of cases out of the Supreme Judicial Court that deal with the home. And I think that involving the search for evidence of whereabouts as opposed to persons? Your Honor, this precise factual situation has not presented itself before in this court. Having said that, I don't think that there's any reason where the Fourth Amendment and Article 14 are based on unreasonableness, and where the facts in this case, while not previously presented in this exact way, fit well within the principles and the standard that's set forth in this case, in this court's cases. In other words, that there was an objectively reasonable emergency and that the police actions were reasonable under the circumstances. So I don't think that there's any reason whatsoever to draw a distinction between the search for persons within the home and the search for information that would lead to those persons and that would enable law enforcement to render assistance to people that they have an objectively reasonable basis to believe are in dire need of assistance.
Now, you say it's objectively reasonable to go back a day later. What's the maximum number of days? Could they go back 3 days later?
I don't think that there's a bright line, just like there isn't with regards to almost anything when it comes to the Fourth Amendment. I think it depends on the circumstances. I think here, during the course of that day, they'd made all reasonable efforts that they could think of to try to locate that family. It might be that in other circumstances it would take longer to exhaust those efforts. It might be in other circumstances that other families would not be as reasonably concerned as this family was, given the relationship that they had with their daughter and their granddaughter and their son-in-law. And so I think all of that would play into the reasonableness of the police decision as to when to go back into that house. But in these circumstances, I think it was entirely reasonable in light of the fact that they'd spent the previous day checking hospitals, they'd sent out a general broadcast, they'd canvassed the neighborhood, they'd attempted to get a GPS location on the car, which wasn't available, they'd checked to see whether the car had low jack, they'd checked with the RMV to see if there had been any recent queries on the car, and all of those things have been unsuccessful. And you also have the family trying to locate the family themselves, trying to call hospitals and to call their daughter again and again, and nobody's responding. So I think that during that day, unlike in, for instance, the Bates case, where we don't know what the officers were doing in the 3-hour intervening period between the call and when they go do the well-being check, we know what the officers were doing. And what they were doing was they were exhausting every reasonable means of attempting to find this family before they went back into the house.
When the police went back the second time, does the record indicate that they were looking for things like, did they listen to the answering machine on the telephone? Were they looking for papers, or were they just looking for the body?
The second time, the record indicates that the officer's subjective intent in going back into the house was to look for paperwork that would have indicated where they would have gone, and to look to see whether or not there were any baby materials, for instance, excuse me, that had been packed up indicating some sort of planned absence. In fact, though, the officers, when they went back into the home the second time, they didn't end up doing any of that because of the fact that as soon as they entered the basement, they began to smell the odor of decomposition. And as they proceeded up the stairs to the first floor, it became stronger. And so obviously at that point, their concern is no longer, their concern has shifted. Their concern is no longer looking for paperwork. It's finding the source of the smell at that point.
Is it your view that your community caretaking exception as applied to the home is the same test as the emergent aid? That is an objectively reasonable basis to believe that there would be evidence of whereabouts? Is that your standard?
Your Honor, I think that the emergency aid doctrine falls within the community caretaking doctrine. I see it as being sort of a subset. I know that it's most often been applied to vehicles. I see police officers, I guess, as having an overarching community caretaking role. And within that falls the emergency aid doctrine. I think that the standard is exactly the same as what it has been in every other case involving the emergency aid doctrine, which is whether there are reasonable grounds to believe that an emergency existed and whether or not the police actions were reasonable in the circumstances. And I think that in these circumstances, they were entirely reasonable. I don't think that there's anything else that the officers could possibly have done to locate this family. I think they'd run out of options, and at this point, the only way to respond to that emergency, which is, again, the disappearance, the completely inexplicable disappearance of a family of 3, including a 9-month-old baby, that the only way remaining to them to locate that family, excuse me, was to go back into that house. I don't think there's any question, as Judge Kottmeyer found, that they could not have obtained a search warrant at that point. I think their actions demonstrate that not only could they not have obtained a search warrant because there wasn't probable cause of a crime, but that in fact nobody is thinking at that point that there's a crime. At that point, the officers' actions are entirely geared towards finding and assisting that family and to assuaging the reasonable concerns of their family members and loved ones.
But you're adding a motivation element to it. Do you think it's appropriate for us to add a motivation element when you include the emergency exception as applied to a home?
No, I don't think so. I think it goes to whether or not their actions were reasonable in the circumstances. I think when we're viewing the totality of the circumstances and whether or not their actions were reasonable, I do think it's important to consider what the well, actually, I do think there's a motivation element because of the fact that the emergency aid doctrine and community caretaking has to be completely divorced from the investigation of any crime. So
you say completely divorced. I assume there was the possibility that there was a crime here. So you're thinking that the primary motivation.
I think there are some cases in which it may be mixed. And I think that there are cases that have expressed that, like I think the Morrison case did. But in this case, I really don't think in this case that there was any idea at the time that there could have been a crime committed. At that point, they're still searching for a family of 3, including the defendant. But I don't think it's adding an element. I think it goes to sort of what the underlying rationale is of the community caretaking rule and the subset of the emergency aid doctrine, which is that it be divorced from the investigation of crime.
Certainly, the judge concluded that the police never sort of abandoned that role in it, and that was that of trying to render assistance in an emergency situation.
That's correct, Your Honor. And I also just would suggest, as one final point with regards to the emergency doctrine, that there's absolutely no reason in these circumstances to apply the exclusionary rule. There's no indication, first of all, that there's any constitutional violation that would undermine the underlying principles of the rule of law. And secondly, I don't think that there's any misconduct to deter whatsoever in these circumstances. If anything, I think that the police actions in this case were commendable. I think that they acted as any citizen would expect them to act in these circumstances.
Let us turn to the judge's voir dire during the course of trial. Your brother says voir dire was inadequate to elicit concerns about the fairness of the jury. I've not seen the questionnaire, nor have I gone back to look at the voir dire. What is your response to that?
Your Honor, I think that the voir dire in this case was extremely thorough. It was extensive, and the juror questionnaire itself that all jurors filled out, again, was probing and thorough and extensive. It consisted of 26 questions. A number of the questions, such as question 16, were geared towards media exposure to this case. Question number 16 is, have you heard or read anything about this case before coming to the courthouse today? 17, have you discussed this case with anyone or overheard others discussing this case before you came to the courthouse today? Have you formed or expressed any judgment or opinion with respect to this case or its merits? Question 19. Question 20 deals with the presumption of innocence, the Commonwealth's burden of proof, and the defendant's right not to testify. And again, number 24 and 25 deal with the impartiality of the jury and whether or not they formed any opinion or any bias or any prejudice with regards to this defendant or his case.
And do we have the sitting jurors' questionnaires as part of the record?
Yes, Your Honor. They're in the Middlesex courthouse. They fill almost an entire box, and they are all available. I went through each of them, and I can assure the court that no juror was seated that answered yes to the question, do you have an opinion as to this case? Do you have a bias or a prejudice that you're aware of as to this case? And when the judge individually voir dired each and every juror, regardless of their answers to that questionnaire, she followed up on all of those questions. She asked every juror whether or not they had any bias or opinion as to this case. And in fact, I think it's worth noting that there were some jurors, at least 4 that I counted, that said that they could be impartial despite what they'd heard or read about the case, and Judge Kottmeyer determined that they weren't being candid with the court, and she dismissed them. So I think that this is a circumstance where you have a very experienced trial judge who makes a very thorough and a very probing inquiry with regards to each juror, with regards to whether or not they've been exposed to media coverage in this case and whether or not they formed any opinion as to this case. And in fact, you can see that she's being discerning and she's exercising her discretion in the jury selection process because of the fact that she dismisses jurors who claim to be impartial, but she believes based on their demeanor or not. So I would suggest that there's no abuse of discretion whatsoever, and I can't imagine what else Justice Kottmeyer could have done in these circumstances to do more to ensure that the defendant had a fair and impartial jury. I certainly think that there's been no showing of presumptive prejudice. As the court knows, that only occurs in truly extraordinary circumstances. I don't think this is one of those circumstances. The fact that there's a great deal of pretrial publicity does not mean that that's the functional equivalent of a televised confession. I think in this day and age, frankly, there's going to be a lot more media coverage of a case like this than there ever has been at any other point in history. And that when we have a free press and we have open courtrooms, that there's a balancing act that we engage in. And when it comes to the jury selection process, Justice Kottmeyer also engaged in that balancing act. And I think that she did everything she could to ensure a fair and impartial jury for this defendant. I'd also just...
Now, Mr. Maidman argues that if he is right, that the inevitable discovery doctrine should not apply. Mm-hmm. Help us to understand how we have applied that doctrine with regard to this rather unusual set of circumstances.
Okay. Your Honor, that was actually what you read my mind. That's what I was about to go back to. I think that in these circumstances, even if the police somehow were not entitled to go back in that second time, the motion judge was completely correct in finding that those bodies would have inevitably been discovered. And with regards to the defendant's argument that in O'Connor and in Benoit, this court said that inevitable discovery can't apply to situations in which a warrant should have been obtained, I think that a fair reading of O'Connor and Benoit is that the police can't claim every time they have probable cause to apply for a search warrant, but decided instead just to dispense with the warrant requirement and go into a private residence. They can't just say, well, we could have gotten a warrant anyway because we have probable cause. I think that that's what O'Connor and Benoit stand for. I think it goes too far to suggest that what they stand for is the inevitable discovery doctrine can never apply to private residences because warrants should be obtained in every single case with regards to a residence. And in fact, I think if you look at the McAfee case and the Streeter case out of the appeals court and the Jesus case out of this court, and I think also the Gomes case out of this court, you'll see that the appeals court and this court has in fact applied the inevitable discovery doctrine when it comes to residences, and frankly when it comes to fairly, in my view, significant violations of the search warrant requirement. The Jesus, I should point out, actually deals with the independent source doctrine, which I also wanted to point out is very conceptually similar to inevitable discovery. That's something that the United States Supreme Court has pointed out and that this court has acknowledged, that they're very conceptually similar doctrines. And so I think in Jesus, where this court applied the independent source doctrine to a violation of the no-knock requirement in entering a private residence, I think that that has significant bearing on whether or not, in this case, the inevitable discovery doctrine can apply in the absence of a search warrant.
Which doctrine is appropriate with regard to Judge Kottmeyer's finding that the Gately's would have, I think the Gately's is the name, would have gone back in?
The inevitable discovery doctrine, Your Honor.
And do we have any case, I don't recall any particular case in which inevitable discovery was based on the conduct of a third party doing something? I
don't think that that precise circumstance has presented itself. I think in the Gee case, G-H-E-E, that case dealt with a private individual lifting up the trunk of a car and finding a dead body there and reporting it to the police. In that case, the court said that because Article 14 and the Fourth Amendment don't apply to non-state actors, that there's no deterrent effect to excluding evidence that's found by private individuals. And I do believe that there's one other case as well, but at the moment.
And if that discovery had occurred 3, 4, 5 days later, any consequence in terms of the evidence that was actually found that was used at trial? I'm trying to think what evidence was used at trial apart from their bodies. Was there any forensic evidence with regard to his involvement?
No, I think the only DNA evidence that was really relevant was in Carver, Massachusetts, at that point in the Matarazzo's home, which was the murder weapon. The defendant's DNA was found in the grip of that weapon, and Rachel Entwistle's DNA was found within the muzzle of the weapon. So the DNA evidence that was relevant to proving the case had nothing to do with the search of the Entwistle home in Hopkinton. There was computer evidence seized from Hopkinton, but that would have been there regardless of whether or not this search had occurred 3 days, 5 days, a month, 10 years later. That evidence still would have been there on the computers. And I also just want to point out that with regards to the primary versus derivative evidence distinction that the defendant urges this court to draw, that every federal circuit, with the exception of one, the District Court of Columbia, every federal circuit has rejected the distinction between primary and derivative evidence. And I would suggest that there's a good reason to do so. As Justice Scalia points out in the Murray case from the United States Supreme Court, it would produce bizarre, uneven, absurd results to draw a distinction between primary and derivative evidence. And I think that this court standard set forth in O'Connor, which is stricter than the federal standard, and I think appropriately so, I think that it more than addresses the issues that could occur when you have a severe constitutional violation, which we did not here. I think that the standard that's set forth in O'Connor, I think it appropriately deals with situations where you have bad faith conduct by police, where you have severe violations. That evidence is going to be suppressed, unlike under the federal rule. So I think that the primary versus derivative evidence distinction is frankly meaningless, especially where we have a remedy set forth by this court that's going to address those situations that truly warrant exclusion of evidence. And, Your Honors, if there are no further questions from the panel, I would just ask that this court affirm the defendant's convictions for the murders of 9-month-old Lillian and her mother, Rachel. Thank you.